Hi, I'm Anna Denton-Jones, and in this second video for Knowledge November, I'm going to tie together some of the sort of legal threads that I see as regards how stress at work can weave its way into the different types of claims that might cross my desk. One of the key aspects of the employee-employer relationship is often described as trust and confidence, this implied term in everybody's contract of employment that has to exist. So the employee has to have that trust and confidence in their employer. And if that gets broken, that may entitle the employee to claim constructive dismissal, for example. So there's always that thread running through situations. And if an employee is being put in an intolerable position as regards the stress that they're suffering from, and it's starting to affect their health, then an employee is always going to be able to argue that trust and confidence has been broken. So if for no other reason, that is a really important reason to take it very seriously if somebody says that they are suffering from stress at work. Even if they're saying that it's just stress in general and we're not sure whether it's work or not, we need to be checking out if it is. From a law of negligence perspective, if we are employing somebody, generally we are entitled to assume that they are fit and well and able to do that job that we've taken them on for. However, at the first sign that we have that they're not coping, we are then being put on notice, perhaps, of there being a problem. And it's incumbent on the employer at that point to then do something about it. So very famous case of Walker and Northumberland was one of the first cases to talk about these sorts of issues, and has become legendary ever since. In that case, a social worker was under such pressure in work that he suffered from a nervous breakdown. At the point of that first nervous breakdown, the employer wasn't particularly in a position where they should have known there was a problem. But at the point that we now know we've got somebody who's fragile, the law tends to call it an eggshell skull. So they've got this thin skull, they're more vulnerable. At that point that we know we've had somebody who has been off sick, suffering the effects of ill health, we now know that they are vulnerable and we should be doing something about it. In that particular case, the employer didn't do a huge amount about it, and lo and behold, the employee returns to work and ends up having a second nervous breakdown. That second nervous breakdown is then reasonably foreseeable for the employer. They knew they had a vulnerable employee, they know they haven't done anything about it, so it shouldn't really be any surprise when there's a further problem. So in a situation where somebody is saying to you, help, I'm struggling, I'm starting to have a problem, we are then on notice and we need to be doing something about it. There have certainly been cases, another example involved HSBC and a part-time worker who was effectively doing full-time hours for part-time pay. And there was a medical report in that case that said to the employer, this person is in danger of becoming really quite unwell. And they didn't do anything to look after her, and lo and behold, she became really quite unwell. Again, the employer is going to be liable in that circumstance because they've been told about it. Generally, I wouldn't worry too much about stress claims. in terms of the law of negligence, it's quite hard for somebody to bring a claim there. The law doesn't generally encourage sort of opening of the floodgates in respect of stress claims. But in a situation where you are being told that there is a problem, then you should really be doing something about it as part of your duty of care towards the person. The other issue that I see quite a lot of relates to working patterns and working hours, and quite a lot of employers who I would say are perhaps ignoring their legal duties under things like the working time regulations that, of course, set out the rules regarding hours, breaks, rest breaks, time off, holiday. So there is always the possibility of that angle being used against an employer. So we should review how our systems are working and make sure we are complying with the law in that regard. Another key area that I think is of growing importance is the public interest disclosure legislation, or whistleblowing. In the context of somebody raising a stress issue with you, you might say, well, that's just personal to them. But we've seen in whistleblowing cases that the courts are not averse to widening out a situation and saying that, as well as somebody obviously complaining about their own individual circumstances, that they're actually telling the employer about a set of circumstances that might be affecting everybody who works at their level in the same category as them. So in that case, it doesn't take a huge leap to find that there is a public interest, in the sense that there's a number of employees in the same situation, particularly, for example, in public sector. So this might be an area where somebody who hasn't got 2 years service, can't, bring a claim for unfair dismissal, might be looking to shoehorn their claim in. And I don't think we can discount that possibility. So watch out for situations where people are, on the face of it, complaining about themselves, but actually it may well turn out to be a public interest disclosure. Another reason for being seen to take the complaint seriously and to do something about it. And of course, complaints don't always come in a form which says this is a complaint along the top of it. It might be much more subtle than that. So it's worth managers understanding how to spot amongst their emails that something may be becoming a complaint, something that's worth talking about in training. Hope you found that useful. Next week, we will be talking about more stress-related topics in relation to Knowledge November. In the meantime, if you've got any questions, adenton@refreshinglawltd.co.uk. Thank you very much.